Hello everybody, welcome to iExamB's Legal Bee. This is Amrita, your law faculty here. In this video, I'm going to continue the series of previous year questions for SEBI Grade A Legal Officer examination. Up till now, we have covered maximum units. There are only 2 units that need to be covered. So this will be the second last video, and again I will be coming with one more video for the leftover subjects from this examination. In this video, we are going to discuss a set of questions from Transfer of Property Act, Torts, Arbitration, and also some questions of trust will be there. Before we start with our discussion, don't forget to subscribe to our YouTube channel and stay updated with all legal related content, recent examination notification updates, and strategic preparation content, everything all at one stop solution Legal Bee. So don't forget to subscribe, and you can call on the number on the screen for more details and visit the website to get an idea about other courses available at iexamb.com. So starting with our discussion quickly. Previous year question series, Torts, Arbitration and Transfer of Property Act. For this, I am taking reference of previous year papers 2020 and 2022. Everybody is well versed with all the series, and those who have not watched the remaining videos of this series can please check out all the videos from the YouTube channel and go through it. ये सारे questions की practice आपके लिए काफ़ी beneficial होगी, and it will give you an idea how the paper is actually going to come in your examination. आप mock tests भी check out कर सकते हो. These mock tests are free at www.iexamb.com, and also you can check out the memory based papers 2020 and 2022 का, that is available at iExamB. You can easily download it. So let us have a quick look at the syllabus of law, that is paper 2. That is going to be Torts, Consumer Protection Act, Arbitration Conciliation Act, Transfer of Property Act, and Trust, which is there in phase 2. phase 1 में trust नहीं है, along with some Latin terms and maxims, because इसमें से भी questions आए थे, and Latin terms and maxims also we are going to take into consideration in this video only. So you can see point number 8, 9, 10 and 11 हम लोग इस वीडियो में कवर करेंगे phase 1 का, and phase 2 का भी point number 8, 9, 10, 11 is divided into 2 parts. ट्रस्ट ऐड हुआ है फेज 2 में. सो ये सारे टॉपिक्स हम लोग इस वीडियो में कवर करेंगे, एंड इन द नेक्स्ट वीडियो वी विल बी कवरिंग अप द यूनिट ऑफ एडमिनिस्ट्रेटिव लॉ, नेचुरल जस्टिस, इंटरप्रिटेशन, जूरिस्प्रूडेंस. इस यूनिट से कितने क्वेश्चंस आते हैं? 7 to 8 क्वेश्चंस आते हैं एज पर द सिलेबस. इफ़ यू कंसिडर द वेटेज ऑल्सो, ये फेज 2 का शेयर किया हुआ है, यहाँ पे 15% का वेटेज है, ट्रस्ट यहाँ पे ऐड हुआ है. सो ओवरऑल एक आप 7 to 8 एवरेज क्वेश्चंस एक्सपेक्ट कर सकते हो इस यूनिट से. इट इज़ हैविंग अ गुड वेटेज. लेट अस सी द फर्स्ट क्वेश्चन, दैट इज फ्रॉम ट्रांसफर ऑफ प्रॉपर्टी एक्ट. व्हेन कैन अ लीज बी टर्मिनेटेड? So when can a lease be terminated? Options are by 6 months notice if it is an agricultural lease, by flux of time limited thereby, by forfeiture. B and C both. All of the above are correct. Answer is all of the above, because all of these are the modes for termination of a lease. So lease is of course a very important topic, and out of that termination of lease you can refer and check out section 111A to clause H of Transfer of Property Act for that purpose. Next question देखते हैं. What is the language used by arbitral tribunal? This is very commonly asked question from arbitration. Arbitration has a good number of questions every year, generally in SEBI, so you have to give good weightage to this subject. Parties are free to determine among themselves. Arbitrator shall determine the language, English or Hindi, English only, Hindi only. So the language of the arbitral tribunal is going to be determined by whom? It is going to be determined by the parties among themselves. Section 22 of Arbitration and Conciliation Act deals with language used by arbitral tribunal. उसमें ये clearly दिया हुआ है. Remember the section number also over here. Is International Commercial Arbitration covered under Arbitration and Conciliation Act 1996? No, it is not covered. India does not support International commercial arbitration is carried out in India under a separate legislation. Part 2 of the Arbitration Conciliation Act itself deals with it. Both C and D are correct on this point. So International Commercial Arbitration, we need to know about it. ऐसा नहीं होना चाहिए आप आर्बिट्रेशन का पूरा एक्ट पढ़ लो और आपको उसकी स्कीम नहीं पता है. यू डोंट नो व्हाट इज कवर्ड अंडर द एक्ट एंड व्हाट इज नॉट कवर्ड. दिस शुड नॉट हैपन. Part 2 of the Arbitration and Conciliation Act deals with it. This is the correct answer. You can check out. Section 2 clause 1 clause F also defines international commercial arbitration. It is a legal and a commercial relationship that is going to exist, and the parties are either a foreign or a national resident or a foreign body corporate or a company or an association body of individuals whose central management is actually being covered, is in foreign hands basically. Part 2 deals with it. How is the place of arbitration determined? Language हो गया, अभी place पर सवाल पूछा गया है. As per the choice of parties, arbitral tribunal shall determine it. Cumulative decision shall be of the arbitrator, and at the time of the hearing, each hearing it can change. As per decision of parties determined by arbitration agreement, B or D. See, be careful of such options also, whether it is and or whether it is or. कई बार हम लोग ये भी skip कर जाते हैं. So इस चीज़ को भी ध्यान में रखिए. अगर यहाँ पे and यूज़ हुआ है तो उसका मतलब अलग होता है. अगर और यूज़ किया है तो उसका मतलब अलग होता है. Or means you have a choice between two options. That is, arbitral tribunal shall determine it, or as per the decision of parties determined for arbitration agreement. So the answer is B. Arbitral tribunal shall determine it. Section 20 of the Arbitration and Conciliation Act provides that the parties are free to determine it, and if not, then arbitral tribunal shall determine it. Okay, so actually the answer is B or D. That is correct over here. B or D. Arbitral tribunal shall determine, or as per the decision of parties determined by the arbitration agreement. So both of these options, any one will take place as per section 20 of the Arbitration and Conciliation Act. So the correct answer is fifth option. That is providing for choice between arbitral tribunal and decision of parties determined by arbitration agreement. The term ab initio means what? To do away with a problem, removal of a theory, gap in a theory or a void, from the beginning when something has occurred. C and D both. And the answer is from the beginning when something has occurred. We have heard of the term void ab initio many times in contracts, so we have an idea about this term already, so it is easy for us to answer. From the beginning when something has occurred means ab initio. If a court has declared something as a case of ab initio also, it means that the court's ruling on it applies from when an act has occurred or when the circumstances for the case in question were in effect, rather than from the point of time when the court actually has ruled on the matter. So the term ab initio can be used in many circumstances. It is not necessary कि सिर्फ void ab initio contracts में ही use होगा. Ab initio word general parlance में भी court कहीं पे भी use कर सकता है. It is a legal term. What is the meaning of the term ad valorem? ये दोनों भी question एक ही पेपर में आए थे, and that too it was asked together only, so you have to keep in mind. ऐसा कई बार हो सकता है, एक तरीके के questions पूछे जा सकते हैं एक ही पेपर में. It's not actually predictable, so you should be prepared. What is the meaning of the term ad valorem? To annul something, to repeal a law, to add value to something, right or ability to get into a property, none of the above. And the answer will be, of course, adding value to something. Ad valorem का actual meaning ये है, adding value to something, and it is a Latin word, of course. Latin ad valentium, meaning to the value, and it is used generally in tax and tax imposed on value of the property. That time we use this term. What is meant by nemo, dat, quod non, habet in law? Maxim related questions हैं ये. Maxim and legal terms. So nemo, dat, quod non, habet in law, very commonly heard maxim this is, and the answer is going to be no one can give what he does not possess. So यहाँ पे कई बार हमें आंसर पता होता है बट confusion होने के chances होते हैं. So keep this in mind. The correct answer is one can give only what he has or possesses. अगर यहाँ पे इस तरीके से भी दिया है उसका मीनिंग आपको समझना होगा. एक्चुअल मीनिंग हम लोग क्या देखते हैं इसका, दैट नो वन कैन गिव व्हाट ही डज नॉट possess. So what they have done it with, they have made it other way around. One can give only what he has or possesses. So even if they give it here, no one can give what he does not possess. नेगेटिव सेंटेंस हो या पॉजिटिव हो, उसका मीनिंग देख के आपको ध्यान से उसको आंसर करना है. ओके, so keep these things in mind, and when you are solving the questions, be very careful about it. So this is a rule that is followed in Sale of Goods Act, contracts. एक general maxim है, ये काफ़ी important है. You can go through it. A football match was going on. During the match, a footballer gets hit by the ball and he is badly injured. In a suit of tort, what is the possible defense that can be taken? Torts में से भी ऐसे कई तरीके के applicability related questions पूछे जाते हैं exams में. So in this, it's all about liability that you have to find out, and it is all about damages as well. So इसमें कौन सा principle apply होगा? ये सारे जितने भी principles हैं, you are seeing these are the principles of tort law. So according to you, which will apply in this? Badly injured है, footballer gets hit, and in a suit of tort, what is the possible defense that can be taken? Now you don't have to see what principle basically plaintiff can apply, but we have to see what defense can be taken over here. So defense that can be taken over here is C, of course, voluntary non-fit injuria. And if suppose this takes place, the match is going on and genuinely somebody gets hurt, then this defense can be taken. But अगर जानबूझ के किया जाता है तो ये defense नहीं लिया जा सकता. So the consent of plaintiff here that he is given, that he is playing the football match, that acts as a defense, and this defense itself is called as voluntary non-fit injuria, which means to a willing person no injury happens. Amicus curiae refers to, and very very easy and very commonly used term in courts as well. So the answer is friend of court. Curiae means a friend of the court, and he is appointed by the court for assisting the court in obtaining any information, any particular expertise if is required. Court requires some assistance, then court tries to appoint a friend of court. Basically, amicus curiae, lawyers are only appointed as amicus curiae. In any matter, for that particular matter only, amicus curiae is appointed by the court. Under Consumer Protection Act 1986, restrictive trade practice means what? A trade practice which tends to bring about manipulation of price or conditions of delivery. A trade practice which affects flow of supplies in the market relating to goods or services in such a manner as to impose on the consumers unjustified costs or restrictions. A trade practice which includes delay beyond the period agreed to by a trader in supply of such goods or in providing the services, which has led or is likely to lead to rise in the prices. Both A and B. A is talking about manipulation of price or conditions of delivery, and B is talking about a trade practice which affects the flow of supplies in the market, and it is imposed in such a manner that consumers are going to suffer due to unjustified costs or restrictions. So these both, or individually or all of the above. Both of these, along with the delay beyond the period that is agreed for delivery of goods by the trader, all these things all together. So this is what is the definition. This is what is talking about restrictive trade practice, and the explanation here has been missed, but the answer will be E, as restrictive trade practice is going to cover all of these particular types of practices that you can see on the screen. Restrictive trade practice includes manipulation of price also. It also includes any practice which is affecting the flow of supplies in the market in such a manner that it is going to impose some unjustified costs or restrictions. That is also a restrictive trade practice. And a trade practice which is going to include some kind of delay, and that delay is beyond the period agreed by a trader, then in that case also it can lead to or is likely to lead to rise in the prices. So that is also actually a restrictive trade practice as per Consumer Protection Act. An arbitration shall be deemed to have been commenced on the date on which a request for the dispute is made, on the date on which request for the dispute is referred to arbitration, on the date on which request for that dispute to be referred to arbitration is received by the respondent, and when the request for dispute to refer to arbitration is received by the plaintiff, date of occurrence of dispute. Now, commencement of arbitration proceedings, another major, we can say, important topic from arbitration this is, and it is deemed to commence from when. This is the question, and let me tell you, this question is asked often from any type of act. Actually arbitration में तो ये पूछा जाता ही है, and the correct answer to this is C. On the date on which a request for the dispute to be referred to arbitration is received by the respondent. So this is going to be received by the respondent. Of course plaintiff का तो कोई सवाल ही नहीं आता है. When that is received by the respondent, from that date arbitration proceedings are deemed to commence. So this you have to keep in mind. Section 43 Arbitration and Conciliation Act का पढ़ना होगा आपको for that purpose, and it is dealt with under Section 43, and Limitation Act also for arbitration shall be deemed to have been commenced on that date only, as is mentioned in Section 21 of the Act. उस दिन से ही limitation period भी start हो जाता है. That also has to be referred. Where the ownership of the property has passed to the buyer before payment of the whole of the purchase money, the seller is entitled to a change upon the property in the hands of the buyer for the amount of unpaid purchase money, to the rents and profits of the property, a charge upon property in the hands of buyer for amount of unpaid purchase money and interest, to bear any loss that is arising from destruction, injury or decrease in value of the property, to pay all public charges and rent which may become payable in respect of the property. Answer is C, where the ownership of property has passed to the buyer. This is what is the important point over here, where the ownership of the property has already passed to the buyer before payment of the whole of purchase money. What is the seller entitled to in such kind of a case? He is entitled to a charge upon the property in hands of the buyer for the amount of the unpaid purchase money and interest. That means जब तक वो सारा money clear नहीं हो जाता है, तब तक seller is entitled to have a charge upon the property because still he has not been paid the full amount. So this is what is the seller's right in that particular case. And Section 55 of Transfer of Property Act is talking about this. Section 55 Clause 4, seller is entitled to what? So this is an important area. यहाँ से seller के जो राइट्स हैं यहाँ से भी क्वेश्चंस पूछे जा सकते हैं. सिमिलरली बायर के राइट से भी क्वेश्चंस पूछे जा सकते हैं. A trustee A for B of a policy of insurance has funds in hand for payment of premiums. A neglects to pay the premium and policy is consequently forfeited. So A is bound to make good loss to B. This situation relates to which duty of a trustee? Now question is something which is related to trusts now. Phase 2 में ऐसे questions पूछे जाएंगे आपको. Phase 1 में तो नहीं है Trust Act. So in this situation, what he has to do is he has the duty to execute the trust, duty to inform himself of the state of trust property, duty to protect title of trust property, duty to take care, duty not to set up a title adverse to the beneficiary. So this correct answer here will be duty to protect title to the trust property. All of these are trust duties only, but you have to apply your mind at that time कि इस particular situation में कौन सी duty applicable है and which will be the correct option over here. And this is actually an illustration that has been picked directly. Illustration F of the Section 15 of Indian Trust Act 1882. यहाँ से directly ये illustration pick किया गया है. A suit for foreclosure is a suit to obtain a decree that a mortgagor shall be absolutely debarred of his right to redeem the mortgaged property. Then a suit to obtain a decree that a mortgagor shall be absolutely debarred of his right to redeem the sold property. Then suit to obtain a decree that a mortgagor shall be absolutely debarred of his right to redeem the mortgaged property. Suit to obtain a decree that a mortgagor shall be allowed to redeem the mortgaged property. None of the above. This question looks descriptive, but actually ये बहुत easy है. Foreclosure के बारे में है. Suit for foreclosure is what? And the answer is first option is only absolutely correct. Suit to obtain a decree that a mortgagor shall be absolutely debarred of his right to redeem the mortgaged property. Section 67 of Transfer of Property Act is talking about the right to foreclosure or sale. In the absence of a contract to the contrary, mortgagee has at any time after the mortgage money has become due to him and before decree has been made for redemption of mortgage property, at that particular time suit for foreclosure can be filed. Foreclosure and redemption, these two topics are very important from Transfer of Property Act, so you have to prepare it well. एटलीस्ट एक क्वेश्चन तो आप एक्सपेक्ट कर ही सकते हो दोनों से, या तो फोरक्लोजर से आएगा या रिडीम्शन से आ जाएगा. Endorsement in relation to an advertisement means what? Any message, verbal statement, demonstration which makes the consumer to believe that it reflects the opinion, finding or experience of the person who is making such an endorsement. This depiction of the name, signature, likeness or any other identifiable personal characteristics of an individual which are making the consumer to believe that it reflects the opinion, finding or experience of the person who is making such endorsement. Then depiction of name or seal of any institution, organization which is making the consumer to believe that again it is reflecting any opinion, finding or experience of the person who is making such endorsement. All of the above are correct, either A or B or C. Now what they have given here, either A or B or C, any one. Correct option is E only. Out of these three, only one can be correct. All cannot be correct. Section 2 clause 18 of Consumer Protection Act, endorsement in relation to an advertisement means what? It can be one. यहाँ पे क्या word use हुआ है और use हुआ है. So applying that only you have to pick the option. मैंने आपको पहले भी कहा है कि you have to take note of these things and be very careful when you are solving the options. अगर आप all of the above कर लेते तो आपका आंसर यहाँ पे गलत हो जाता था. In the provision it is clearly mentioned it can be this or this can be depiction, or this can be depiction of name, signature, anything relating to individual, or it can be depiction of name or seal of any institution. It can be any one of these. The meaning of the term amicus curiae? Amicus curiae, this question has been repeated again in examination. Again I have taken it over here. Options थोड़े से अलग हैं क्योंकि ये दो बार आ चुका है इन दोनों पेपर्स में. So that is why it has come again, but the answer remains same, friend of court. Which of the following means Audi Alteram Partem? Again, a principle of natural justice has been taken up over here. Audi Alteram Partem. It is generally asked in in general parlance also, and detail में भी principle of natural justice से कोई questions हम expect कर सकते हैं. And everybody knows this. This is very easy. Everybody knows about Audi Alteram Partem. It means right to fair hearing also and listening the other side also. So option A and B both are correct over here. This principle is the basic concept of principles of natural justice. A lessee may remove his property that is attached to the earth at any time after determination of lease, when he is in possession of property, before he leaves possession of property, after he leaves possession of property, A and B or C. Again be careful over here what they have used, A and B or C. Okay, so the correct answer over here is E only, because all of these conditions are correct till C. Okay, D is not. At any time after determination of lease, and when he is in possession of property, or before he leaves the possession of property, because both of them cannot exist together. And you can refer section 108 clause H of Transfer of Property Act for this purpose. You will find it how exactly it is and or that has been used over here. When does an arbitration proceeding actually commence? Again, it is relating to commencement of arbitration proceedings. ये पहले भी question आ चुका है. When the arbitration dispute is received by respondent, made by respondent, and everybody knows the answer of this. सिर्फ options यहाँ पे change हुए हैं. Correct option is A only. Request for dispute to be referred to arbitration is received by the respondent as per section 21 of the Arbitration and Conciliation Act. In which of the following cases can courts intervene in an arbitral proceeding? When arbitration is completed, when arbitration fails, when it is proved that one party was under some incapacity, arbitral order is signed. In no cases court shall intervene in an arbitral proceeding. So this is very, very commonly asked concept, judicial intervention in arbitration proceedings. So this is an important topic for you. Question कोई भी form में आए, you should be clear कि जुडिशियल इंटरवेंशन इन आर्बिट्रेशन ये काफ़ी सेलिब्रेटेड टॉपिक है आर्बिट्रेशन एंड कंसीलिएशन एक्ट का. सो यू शुड बी प्रिपेयर्ड विद इट इन अ गुड मैनर. अगर कोई भी ट्विस्टेड क्वेश्चन भी आए, यू शुड बी एबल टू आंसर इट. आंसर इज सी. व्हेन इट इज प्रूव दैट वन ऑफ द पार्टी वाज अंडर सम इनकैपेसिटी, देन द कोर्ट कैन इंटरवीन. मोस्ट अप्रोप्रिएट आंसर यहाँ पे यही है. इन नो केस कोर्ट शैल इंटरवीन, ऐसा नहीं है. जुडिशियल इंटरवेंशन मिनिमल होगा, बट ऐसा नहीं है कि बिल्कुल भी नहीं होगा. सो आर्बिट्रेशन कंसीलिएशन एक्ट 1996 सेक्शन 34 यू कैन रेफर फॉर दिस पर्पस. विच ऑफ द फॉलोइंग इज अ पार्ट ऑफ फास्ट ट्रैक आर्बिट्रेशन? फास्ट ट्रैक आर्बिट्रेशन it is a concept which has been added by amendment to the act, and which of the following is a feature of fast track arbitration? Basically, out of all these options they have asked you, parties can omit oral hearing, conduct oral hearing only, 2 arbitrators are appointed, procedure is completed in 15 days, it is completed in 3 months. Now you should know it, only then you can answer it. इस तरीके का क्वेश्चन है, ये नॉलेज बेस्ड क्वेश्चन है. टॉपिक इंपॉर्टेंट है तो ऑफ कोर्स यू आर एक्सपेक्टेड दैट यू शुड प्रिपेयर इट. आंसर इज ए. पार्टीज मे ओमिट ओरल हियरिंग इन फास्ट ट्रैक आर्बिट्रेशन. ये एक प्रोसीजर है एंड इसमें ओरल हियरिंग ओमिट किया जाता है कई बार अगर पार्टीज अग्री करती हैं. ऑफ कोर्स इट इज़ वॉलंटरी इन नेचर एंड दे कैन सबमिट देयर आर्ग्यूमेंट्स इन राइटिंग. सो एज पर सेक्शन 29B ऑफ आर्बिट्रेशन एंड कंसीलिएशन एक्ट, पार्टीज में ओमिट ओरल हियरिंग. Restrictive trade practice means what? Again, this is a question from Consumer Protection Act. Trade practice which intends to bring about manipulation of price, which intends to bring about manipulation of conditions of delivery, which affects the flow of supplies in the market relating to goods or services in such a manner that is imposing on the customer some justified costs, A and B, A, B and C. Now be very careful over here. I have given you the answer because ये concept हम लोग पिछले question में भी discuss कर चुके हैं. But यहाँ पर slight difference क्या है? Why we have not taken option C as correct over here? But this was there in the previous question also. But वो question का framing थोड़ा सा अलग था. In that it was used unjustified costs and यहाँ पर word use हुआ है justified costs. So इसका पूरा meaning change हो जाता है. So ये केयरफुल होना ज़रूरी है यहाँ पे आपको. यू हैव टू बी वेरी केयरफुल व्हेन यू आर रीडिंग द क्वेश्चन एंड ऑल्सो द ऑप्शंस. इफ़ यू आर क्विकली गोइंग थ्रू इट, आप क्या चूज़ करते हैं यहाँ पे? ए, बी एंड सी चूज़ कर लेते एंड आपका आंसर गलत हो जाता. सो जस्टिफाइड कॉस्ट के लिए ट्रेड प्रैक्टिस रेस्ट्रिक्टिव नहीं मानी जाएगी. इफ़ इट इज़ अफेक्टिंग द फ्लोज ऑफ supplies in the market in such a manner that it is imposing on the customer an unjustified cost, then that will be a restrictive trade practice. And you can refer the provision for this. Restrictive trade practice is an important topic, so you can go through it. यहाँ पर word unjustified costs use हुआ है, that you should go through. Persona non grata means persona non grata, insane person, person who is not grateful, wrong person, unacceptable person, unavailable person. So persona non grata is a person who is unacceptable. Persona non grata means unacceptable or unwelcomed person. This maxim has evolved from where? From the area of diplomatic relations. This has come. foreign diplomats are unwelcomed in the country, there they are known as persona non grata. They are not acceptable or welcomed. Uninvited, जैसे हम लोग कहते हैं बिन बुलाए मेहमान, like that you can remember this maxim very easily, persona non grata. And Article 19 of the Vienna Convention on Diplomatic Relations is talking about this particular concept. So you can refer this. कई बार ऐसे मैगजिम्स आ जाते हैं, हम लोगों ने जनरली सुने नहीं होते हैं एंड हम जम्बल्ड अप हो जाते हैं. थोड़ा सा अगर हमें पता नहीं है तो उस टाइम पे हमें थोड़ा सा अपना लॉजिक भी अप्लाई करना होता है वर्ड्स को देखकर, इफ पॉसिबल. Tort is defined under Section 2M of the Limitation Act. Which of the following is the right definition of tort? Now question ऐसा भी पूछा जा सकता है कि tort statutorily defined है क्या, and अगर है तो कौन से provision में है? So Section 2M of Limitation Act. अब यहाँ पर पूछा है which of the following is the right definition of tort? As per Section 2M you have to answer this. Civil wrong तो ये सब जगह आएगा ही. You know about the general definition of tort. Not defined statutorily है क्या? नहीं. It is defined statutorily, we know that. So the answer is going to be D. Tort is a civil wrong which is not exclusively the breach of a contract or the breach of a trust. Very simple definition it is. वही है सब कुछ. अगर आप एक simple reading भी करोगे, you can answer this question very easily. Vicarious liability is liability for wrong committed by a servant, liability for wrong committed by a servant in the course of employment, liability for wrong committed by a servant for the benefit of a master, liability for wrong committed by master along with the servant, liability for wrong committed by servant in case of a rich master only. Again simple logic apply करना है. सिंपल डेफिनेशन है, ज़्यादा कॉम्प्लिकेटेड नहीं है, कॉम्प्लिकेटेड करना भी नहीं है उसे ऑप्शंस को देख के. Liability for wrong committed by servant in the course of employment is vicarious liability. As per the doctrine of vicarious liability in tort law, that has to be इसमें rich master हो poor master हो उससे कोई लेना देना नहीं है. It is going to be committed by the servant and that is in the course of the employment that he is doing it, and the servant will be held liable along with the master. This is also one of the thing. ऐसा नहीं है कि सिर्फ master liable होगा, servant will also be liable along with the master. Master is liable not only for the acts that the servant has committed but also for the acts that are done by him that are not explicitly authorized. लेकिन अगर वो course of employment में है then the person will be liable. Even उसने अगर वो explicitly authorized नहीं किया है master को, then also he will be liable for those acts. Whoever fails to comply with the order of State Commission can be penalized by State Commission. In such a case, the State Commission shall have powers like that of a. Now, State Commission, कौन से State Commission की बात हो रही है यहाँ पे? Consumer Protection Act. The unit that we are discussing that consists of Consumer Protection Act. So, whoever fails to comply with the order of a State Commission, he can be penalized by State Commission, no doubt. But the powers that State Commission is having are powers like that of a district judge, or a judicial magistrate first class, or a judicial magistrate second class, a sessions judge, or a high court judge. This we have to be aware of. इस पर direct provision है act में. Judicial magistrate first class, section 72 of the Consumer Protection Act 2019 talks about it. अगर district commission, state commission या national commission के कोई भी order या punishment को नहीं माना जाता है, then the powers that are going to be resting with district commission, state commission or national commission shall have the power of judicial magistrate first class over here. And they will be all of them, not only state commission, even district commission. हम सोच सकते हैं कि district can be JMFC, state can be high court. ऐसा नहीं है. District, state or national कोई भी हो, they shall be deemed to be a judicial magistrate first class for the purpose of code of criminal procedure. They will be having powers alike, all three of them. JMFC के तरह के powers होंगे उनके पास. A leaser is bound to disclose to the leasee any material defect in the property. Lease में से काफ़ी questions आपको देखने के लिए मिलेंगे कि be aware of this and अच्छे से करके जाइए lease with reference to the intended use of which the latter is and the former is not aware and which the latter could not with ordinary care discover. with reference to its unintended use of the which former is and the latter is not aware, and which the latter could not with ordinary care discover. With reference to intended use, former is and the latter is not aware, and the latter could with ordinary care discover it. आप देख रहे हो ऑप्शंस में काफ़ी स्लाइड माइन्यूट चेंजेस हैं, ज़्यादा डिफरेंस नहीं है. सो अगर आप चाहें तो इसको वीडियो को स्टॉप करके भी ऑप्शंस को चेकआउट कर सकते हो आराम से, या फिर पीपीटी भी डाउनलोड कर सकते हो. दैट इज़ अवेलेबल इन द डिस्क्रिप्शन ऑफ द वीडियो. बट द क्वेश्चन इज एक्चुअली वेरी इजी. जस्ट लुक्स डिफिकल्ट, इट लुक्स लेंदी, but it is easy, and the answer is D. A leaser is bound to disclose to the DC any material defect in the property with reference to its intended use of which the former कौन है? leaser is, and the latter कौन है? leasee is not aware, and which the latter could not with ordinary care discover. Latter means leasee ordinary care से अगर discover नहीं कर पा रहा है and leaser is already aware of that, then he will be liable. अगर आपको प्रोविजन नहीं पता है तो भी यहाँ पे आप आपका माइंड अप्लाई करके, लॉजिक अप्लाई करके इस क्वेश्चन को आंसर कर सकते हो. कई तरीके के इस तरीके के जो क्वेश्चन होते हैं इसमें आपको आपका लॉजिक भी अप्लाई करना होता है. विच ऑफ द फॉलोइंग इज नॉट अ ड्यूटी ऑफ द मॉर्गेजी? Managing the property, committing an injurious act to the property, keeping clear accounts of sums received and spent, both managing property and committing an act which is injurious to the property, and A, B and C, all of them. Which of the following is not पूछा गया है? Keep in mind, be aware, not a duty of the mortgagee. Many times we think we miss this not, and then we do the answers wrong. Answer is B, must commit an act injurious to property. Mortgagee of course is not going to do such kind of act, and managing the property is his duty, and clear accounts रखना ये भी mortgagee की duty है. So section 76 of Transfer of Property Act is directly talking about liabilities of mortgagees in possession. When they are in possession of the property, they have to manage it well and keep clear accounts of sums that are received and spent on the property. This is mentioned in clause A directly of section 76. ये आप रेफर कर सकते हैं. An application for arbitration shall be filed by defendant before submission of written statement at any time when the suit on same subject matter is already filed. At any time provided the suit on the subject matter is not filed yet, cannot be filed, court shall refer the matter for arbitration. Application आप नहीं file कर सकते. None of the above. Now this is actually, it looks easy, but ये थोड़ा सा confusing हो जाता है when we refer the options. इस तरीके के भी क्वेश्चन से आपको अवेयर रहना होगा. When you are referring the options, you get bit confused. You feel that you get confused कि सारे options आपको सही लगने लगते हैं. And the answer is A. Simple है. Defendant can file an application for arbitration before the submission of written statement. This is the most appropriate option over here. आप अगर बाकी के options को यहाँ पर चेकआउट करोगे तो आपको कोई भी option यहाँ पे सही नहीं लगेगा if you apply the simple logic. Section 8 of the Arbitration and Conciliation Act. When there is an arbitration agreement, judicial authority before which an action is brought, which is subjected to an arbitration agreement, party applies for it, can apply for it. Apply for it means make an application. But when? Before the submission of first statement on the dispute is made. Before that it has to be done. तो यहाँ पर अगर आप देखोगे जितने भी ऑप्शंस हैं, फर्स्ट ऑप्शन इस सिचुएशन में फिट बैठ रहा है. ऑफ कोर्स डिफेंडेंट तो रिटन स्टेटमेंट देगा, तो उसका रिटन स्टेटमेंट देने के पहले फर्स्ट submission of written statement जो है that will come under this category. Before that, first statement on substance of the dispute is being made. Before that, it can be referred for arbitration. Which of the following amounts to breach of trust? Now this was the next question from Trust Act. Trust Act has less questions, no doubt, but syllabus is also very less. Only you have to do parties to a trust deed. What is a trust? Basic out of that. Failure of trustee to carry out any specific duty that is entrusted to him. Failure of all the parties to carry out any trust duties. Duties of a trustee बहुत important है, उसी में से दोनों क्वेश्चन देखने मिले हैं हमें यहाँ पे. एंड जनरल भी अगर आपने आपका लॉजिक अप्लाई किया, यू कैन आंसर इट. आंसर इज ए. फेलियर ऑफ अ ट्रस्टी टू कैरी आउट एनी स्पेसिफिक ड्यूटी एंट्रस्टेड टू हिम. जनरल ऑप्शन है, बहुत ही जनरल आंसर है. सेक्शन 3 अगर आप रेफर करोगे ट्रस्ट एक्ट का, इंटरप्रिटेशन क्लॉज है दैट कंसिस्ट ऑफ ब्रीच ऑफ ट्रस्ट, बिकॉज ब्रीच ऑफ any duty is actually breach of trust. Conciliator may at any stage of the conciliation proceedings make proposals for a settlement of a dispute. Such proposals are what? They need not be in writing but need to be accompanied by a statement of reasons. Need not be in writing and no need of stating reasons also. Writing होना चाहिए but reasons की ज़रूरत नहीं है. Need not be in writing and need to be accompanied by a statement of reasons, and need not be in writing and need not be accompanied by statement of reasons. So conciliation, one question has been asked from proposals for settlement. Of course, arbitration you should be aware with arbitral award. Similarly for conciliation, you should know what are settlement agreements. You should know what proposals are made by the conciliator, in what way it is made and how it is approved by the parties. ये basic procedure है. And the answer is E. It need not be in writing and need not be accompanied by a statement of reasons, because that formality of procedure has been relaxed in conciliation. Answer is section 67 of the Arbitration and Conciliation Act 1996 talks about it. It talks about the roles of a conciliator. So you can refer that and also understand the procedure very nicely. Arbitration, conciliation, these topics, and in fact this unit entirely I would say is very good unit. Here once you have studied the concept well, you can easily answer these questions. आपको याद भी रहेगा and आप अच्छा score कर सकते हैं. On death of a party, arbitration agreement, what will be the effect of death on a party on the arbitration agreement? Now they have changed the options. In all the 5 options, shall be discharged by death of party, either as respect to the deceased, it should be not be discharged, it should not be discharged by death of party respect to the deceased, shall be discharged by death of party as respect to the deceased but not as respect of any other party. इसी को थोड़ा चेंज करके दिया हुआ है. And the answer is C. करेक्ट ऑप्शन क्या है वो देख लेते हैं हम लोग. shall not be discharged by the death of any party thereto, either as respect the deceased or as respects to any other party. So on death of party, arbitration agreement shall not be discharged by the death of any party thereto, either as respect to the deceased also or as respect to any other party also. So section 40 of Arbitration Conciliation Act you can refer for this purpose. Arbitration agreement not to be discharged by death of party thereto. So this was all from this unit. We have discussed a set of 32 questions. Do refer these questions. It is a very good practice for you people. Now I am left with one more video from this series. I will be coming up with this video soon and take benefit of all these videos. अगर बाकी के videos आपने नहीं देखे हैं इस series के, do check it out at Legal Bee. And also iExam has expert faculty for legal, me myself Amrita Johar, Miss Neha Dubey and Miss Vidika Bansal. We are here to guide you on every aspect as you want. अगर आपके कोई भी queries हैं, you can write to us in the comment section of this video also, and also you can call on the number that is visible on the screen, and anytime you can write to us at hello@iexambi.com also. We are here to help you. आपके कोई queries हैं, कोई video requests हैं, do write to us and prepare 50% faster with iExambi. Don't forget to subscribe. Thank you so much.